Welcome to Creamer Media's Polity. I'm Natasha Odendahl. With me in studio is Daria Tanziani, chairperson at law firm Adams & Adams, to talk about the effects of the Intellectual Property Rights from Publicly Financed Research and Development Act. Welcome, Daria. Which institutions or other entities, businesses and parties will be affected by the Act?
Natasha, the Act is going to cut across quite a wide swathe of these institutions. First of all, your higher education institutions, as defined in the Higher Education Act, basically the universities and your technicons and your universities of technology. Secondly, there's a category that is defined in the Act itself, which includes typically institutes which are funded by the state to do research, such as CSIR, Agricultural Research Council, the Nuclear Energy Corporation, the Medical Research Council, Council for Geoscience, and the like. Also affected, of course, will be private entities who contract institutes that we've discussed to do research for them, and then also private entities who do research funded by the state. And then, of course, also affected will be the creators of the intellectual property.
Who would be the owner of the IP emanating from publicly financed R&D?
Right, well, I think you must distinguish here between two broad scenarios, and that is sole ownership and co-ownership. Sole ownership, generally defined by the Act as being the recipient normally, one of the categories. And the recipient is either one of the institutes that we have discussed already, alternatively a juristic person who has been conducting research funded by the state. Also, sole ownership would be in the hands of, if that entity declines to take ownership of the intellectual property, then the NIPMO, which is the National Intellectual Property Management Office, created in terms of this legislation, has the option to take ownership of the intellectual property. If NIPMO decides not to take ownership, then any private entity which has contributed funding to the research has an option to take ownership, sole ownership, subject though to granting certain rights to the creator, which is quite an innovative part of this legislation. And that means that the creator is entitled by law to get at least the first 20% of all revenues for the first R1,000,000 arising out of intellectual property or commercialization thereof, and at least 30% of anything after the first R1,000,000. Failing the private entity taking ownership, then the creator will be given the option to take ownership of the IP. And then there's another category which is very important, and that is private entities who will do the research or contract research to institutions on so-called full cost funding. And when that happens, then the Act actually doesn't apply to them. And then contractually, in cases like that, normally those private entities will want to take full ownership of the IP. So that covers the sole ownership. Co-ownership normally will arise where a private entity contributes some resources to the research, and that could be, for example, background IP, which would enable the institution to get going with the research. And in those circumstances, then co-ownership of the IP resulting from the research would arise.
Does the Act prescribe the manner in which the IP has to be commercialized?
The Act is fairly prescriptive in that regard. Broadly speaking, commercialization means any process by means of which the intellectual property is either adapted or used for the benefit of the people of the Republic, alternatively commercial use on reasonable terms. This is a brand new piece of legislation, so quite what the latter term means is not quite clear. But there are other provisions which are very important to note. For example, preference is given to black empowerment entities for commercialization of the IP. Preference is given to small entities. Preference is given to non-exclusive licenses. Then also the rights of the state in terms of this commercialization are very important. The state must have a right to the IP, to use the IP and commercialize it for purposes of the country's health, security or other emergency needs. And any commercialization agreement must also contain provisions which allow the state, if you fail to commercialize the IP for the benefit of the Republic, to step in and renegotiate via NIPMO your license to commercialize the the IP, and if agreement can't be reached on that, then NIPMO can take ownership of the IP. Also, in terms of offshore transactions, you need, for a license with an offshore entity, you need NIPMO's approval, and you need to do it in accordance with the prescribed regulations. And if you want to assign this IP to an offshore entity, you then have to show that there is no capacity in South Africa to commercialize the IP, and that the commercialization offshore by virtue of the assignment will be for the benefit of the Republic.
Okay. Thank you, Dario. That was Dario Tanziani discussing the effects of intellectual property rights from Publicly Financed Research and Development Act.